We don't require to hear you on the JS2 with you, Mr. Knox. Thank you very much. Yes, Mr. Southey.
My lords and my lady. Can I deal with my learned friend's submissions, not in the order in which he made them, but hopefully by topic, because that may assist, I hope. At the heart, obviously, of my learned friend's submissions was a submission, essentially, that the way in which the court should look at this was in two stages, the jury issue. The first being, was the judge obliged to discharge one juror, and the second being, was the judge then obliged to discharge others because of the potential impact of that one juror. Our submission is that that approach is flawed, and we make that submission for two reasons, two independent reasons. The first is this. My learned friend said, albeit slightly half-heartedly, one might think, when asked a question, that the test essentially that should be applied is not the Porter and McGill-Lowell test. It was one, I think he referred to it ultimately as being possible bias, not appearance of bias. In other words, as I understood it, actual bias, not apparent bias. In our submission, that was an important submission for him to make, and he needed to make that for two reasons. Firstly, because he accepts that ultimately this jury included, to use his language, a bent juror. In terms of the fair-minded bystander, that immediately must raise eyebrows. But secondly, probably more importantly in one sense, his submissions this morning focused on what whether or not the judge was acting reasonably. That in our submission is not ultimately the key question. The key question is whether or not the fair-minded bystander would effectively conclude there was a real risk of bias. Now, the fair-minded bystander test has been consistently, I'll just give you the references to it, applied by criminal courts. It was applied in Brown, as you saw when I opened, which is at page 6330, paragraph 38. It was also applying Brown in Morrison, which my learned friend took you to, page 7564, paragraph 36. And there's good reason for it to apply. There's no suggestion anywhere that in the case law that there's a different test, but the good reason for it, and it links in with the submissions I made yesterday about Lowell. You'll remember in Lowell, which is 6318, the court emphasized essentially that the reason for the fair-minded bystander test was the need to ensure that there was confidence in the justice system in a democratic society. The language used, if I remember right, is public perception is key. And that need for public perception, it must apply equally as powerfully in crime, if not more powerfully, where liberty is at issue, confidence in the jury system is important. That was part of Lord Justice Bingham's, as he was then, remarks in Putnam. And so public confidence remains as important. And it should be noted, again, I won't take you to it given time, but in Gregory in the United Kingdom, consistent with what I've just said, a criminal case, 7930, the European Court of Human Rights started by directing themselves that courts must inspire confidence, same principle as Lowell, paragraph 43, and referred to the need for there to be impartiality subjectively as well as objectively. In other words, it must appear, a criminal court must appear unbiased. And there is nothing in our submission that supports a departure from Porter and McGill. One thing I should say, just because there was some suggestion about what was argued in the Court of Appeal, paragraph 240 of the Court of Appeal's judgment expressly refers to an argument that Porter and McGill applied. It was said that the judge had applied the wrong test. That's electronic bundle 5870. That is preceded, just in terms of what's argued, at reference page 5867 to 68, paragraph 234 by reference to the fact there was an argument about overcompensation. So overcompensation clearly was before the Court of Appeal.
What was the paragraph reference for that?
234.
234, thank you.
Second point, whether or not I'm right about the first point, in our submission, the prosecution's approach is essentially of saying you can have a jury with one biased member and it's still a lawful jury is inconsistent with the statutory scheme. And there are a couple of features that I'll just remind you of. Firstly, if you go to, and these are 6803 or the new version of the Jury Act is in same terms essentially for these purposes. 31.3, you will remember, is the provision that talks about how a jury is properly constituted if it's not reduced by more than one. But if you are discounting someone essentially on the basis that they no longer should properly be a member of the jury because they are bent, again to use that language, in those circumstances, the jury ceases, we would submit, to be properly constituted. Now, one particular reason for that is that if you look at 31.4,
it might be helpful for us to have this in front of us in the correct version, which was sent by email to us earlier this morning.
I'm sorry, I've got it. That's why I've got the iPad up, so I've got the correct version. So I don't think the language changes for these purposes, but I absolutely accept the point that it's better to have the source.
What time is it sent? My email has crashed.
Oh, I see.
Added to SharePoint. It's on SharePoint.
I'm disconnected. I'm disconnected. Yeah, I'm disconnected. I'm not getting any emails.
I got it.
I think within the internal pagination, it's page 18.
Yes.
I think four of us have the
Sorry.
Latest version. My email is disconnected.
I'm sorry.
It should be on SharePoint as well.
No, this version came in. Yes, it's not appeared on mine, probably for the same reason.
You just have to manage.
I'll manage. Yeah.
Yes, Lord Lloyd Jones will manage with the
Thank you.
2016 version.
Thank you. 31.3 is the provision essentially that talks about a properly constituted jury and makes it clear that if the numbers are not reduced by more than one, the jury remains properly constituted. Well, we would submit that if someone is biased and essentially being discounted by the judge as on the basis that essentially the verdict can be delivered by 10, that is inconsistent with 31.3. But 31.4, even more importantly, in one sense, deals with what a verdict of 11 jurors, a verdict of 11 jurors is treated. It provides that it will be unanimous, essentially deemed as unanimous, even though one person has been discharged, demonstrating really that the expectation of the legislation is that all jurors will participate. And that's even clearer, we would submit. If you go down in the version that we've got to, it's page 24 within the pagination of the document, section 44.1a, which is the provision that allowed a majority verdict. And of course, that provides, as the court's well aware, and as is common, that you can't immediately go to a jury verdict. And that's important because what it's demonstrating is that the starting point should be that all jurors participate in the verdict, and all jurors should, as far as possible, be in agreement about the verdict. If that's not possible, then you can go to a majority verdict. But the view is that everyone should participate. All of that explains in our submission why, and none of this is sort of unusual or it's reflected broadly in similar provisions or similar approaches in England and Wales. All of that explains why in Putnam, you will remember, and it's page 7579.
Sorry, yeah.
Sorry.
Can I just check? Are you able to help us on whether the murder is type or the murder falling within section 44(1)A?
Yes, capital.
It wasn't, and that's why when I used 44(1)A, I meant capital A, not little a, because that's why the majority verdict could be reached, as obviously it eventually was. But as I say, the key point we make about that is that demonstrates the idea that the jury should, as far as possible, be coming to a collective decision. And that all explains. You'll remember, if you go back to Lord Bingham at Lord Justice Bingham, as he then was, at 7579, the passage towards the bottom of the page that I took you to yesterday, Lord Bingham bases his approach in circumstances where, on the material they had, essentially, it was one juror who was approached. He bases his approach on the need for collective and individual integrity. He's making it clear, and we would submit this is consistent with the statutory scheme. The jury system isn't a system where you can say, well, you've got 11 individual actors. He's saying you've got 11 people who have individual responsibilities, but they also act as a collective. And that's what the legislation is plainly intended to represent. And that is reflected, I won't take you back to it, in the Bechandan decision that we produced yesterday from the Guyanan Court of Appeal. It explains why a trial without its full numbers can't be regarded as a valid trial, even though in principle it might have been possible to proceed with the number that was who were actually involved in the verdict. And fundamentally, there is a good reason for that. And it's this. Everyone remembers, most lawyers remember very strongly 12 Angry Men. And it's the point about that is you can have one member of the jury who is completely out of line with everybody else, who persuades everybody. And your right is to have that one person come forward. And one of the real risks in these circumstances is that the corrupt juror, my learned friend, because he needs this, has to accept that the corrupt juror can participate. It's potentially important he participates because he might be the minority, the person who is going to try and persuade everybody else that he's right on the evidence. But of course, there is then a problem because all the other jurors, if they're aware of this, may well, understandably, want to discount his views perfectly properly in one sense, you would think. But that's the fundamental problem that you've got in this case. And that's one of the reasons why you can't separate this, because you can't separate the questions in the way that my learned friend does, because he needs to say, because he needs the corrupt juror to remain on the jury, that corrupt juror needs to be able to participate in principle in the decision making, but it's very difficult to see how they can do that without then there being a problem. And all of that statutory scheme obviously needs to be viewed in light of the fact that there is a right under the Charter, Section 16, to an independent and impartial tribunal. And my learned friend took you to the structure of the Jury Act. He made a number of points. His basic point was essentially that although if you had an incapable juror, for example, someone suffering from mental disorder, they would have to be discharged. But in some sense, a biased juror was different. But the fundamental problem is with that submission that the biased juror, of course, is incapable of complying with their oath. By definition, if they are biased, the oath in this sort of situation, in any event, the corrupt juror has already said that they're not going to comply with their oath. Why are they any different to others who are effectively discharged because they're unable to comply with their oath? Now, my learned friend in submissions essentially argued that one of the reasons why the judge wasn't obliged to discharge the briber was that they apparently favoured the defendant. And he emphasised the fact that the forewoman had given evidence or had given an account that nobody was listening to the person offering bribes. I think the reference is electronic bundle 517221. But that demonstrates in one sense the problem, because it demonstrates how once you've got to this situation, you're not adopting, the jury wasn't adopting the Putnam approach. It wasn't taking collective responsibility, essentially. It was saying, you need to be isolated. In terms of the impact on the jury, what my learned friend failed to address in my submission is how the judge was actually in a realistic position to address and understand the impact on the jury. He had no evidence about how long the jurors had been aware of this, the Putnam point that the longer you're aware of it, the more embedded prejudice can become. He had no explanation as to why the jurors hadn't drawn attention to it. The jurors were not asked individually if they could put the bribe to one side. And so, on the face of it, he had very little information about impact. And that meant it was very difficult, we would submit, for him to assess. Now, his sort of fundamental point about considering the impact is that what the judge was entitled to take account of, or what justifies the approach of the judge, was that discharging the whole jury would have brought the system into disrepute. It would fundamentally undermine the jury system. Firstly, there's no indication these circumstances are common, but if there is a problem along those lines, the answer is for the legislature to introduce legislation such as England. If the system becomes undermined, essentially, there are solutions. The solution isn't to allow a trial to continue in circumstances where there is a lack of independence. That was the context, though, of my learned friend's submissions, which fundamentally were that the judge's discretion was exercised correctly in not discharging the jury.
I take it there's no evidence about jury tampering in Jamaica that's before us?
No.
Thank you.
Not that, certainly not that I'm aware of. My learned friend's next submission, based on what I've just said, was that the judge exercised his discretion correctly. It was an exercise of his discretion. Firstly, given what I've already said about the Porter McGill test, the Lowell test, in our submission, that's the wrong question. The real question here is, was the constitutional right to an independent trial by an independent court breached? That's important because the suggestion was essentially all that the judge had was a mere allegation. Firstly, we of course know that there was in fact a conviction, but secondly, in any event, the issue is real risk. The learned friend said the judge was entitled to rely on the forewoman's role, and in particular the fact that she said that none of the other jurors had taken a bribe and that they would follow their oath. Part of the problem with that, the primary problem with that, of course, is where you have unconscious bias, by definition, it is a problem the individual may find difficult to discount whatever their sort of professed approach will be to decision making. That's why, if you think about Putnam in my submission, Lord Justice Bingham made it clear there comes a point where you have to discharge the jury if, for example, the poison has been allowed to spread for too long. The second point is, of course, that was all information obtained through the forewoman, and that is a problem because of the lack of any public record of what the jurors themselves said, and I'll potentially come back to that. The third point my learned friend made was that the Court of Appeal upheld the conviction. Unsurprisingly, we would say that the approach of the Court of Appeal, particularly paragraph 238, and I won't take you to it, everyone's familiar with it, obviously demonstrated a flawed approach. Some further points that my learned friend made to justify essentially the outcome in this case. The first was that the bribe was offered by someone who was seeking to favour the defendant. In submissions, unlike in writing, it appeared to be accepted that there's no evidence that any of the defendants was to blame for the bribe. That's important because it means none of them have taken actions which could in any sense be said to be effectively a waiver of their rights. But more importantly, Putnam is clear authority, and it's 7579, that there is a risk of prejudice against, and that's obvious. People do overcompensate. My learned friend said, you can tell that the jury is independent because it acquitted Mr. Williams. Already made the point, effectively, that we would submit that the jury simply couldn't lawfully deliver a verdict. But in any event, bias doesn't necessarily mean that someone will always deliver a verdict that is the verdict sought by the party they favour. Bias means essentially you're more likely to favour one party than the other. The fact that the evidence, put it this way, you can have a case where a biased individual acts against their biases because the evidence is so overwhelming. That doesn't mean they weren't biased. It doesn't mean that there isn't a higher threshold to overcome if the bias is against you. Bias simply means you favour one party over the other. I mean, that's in our submission fundamental. And that's why the acquittal of Mr. Williams, in circumstances where the evidence against Mr. Williams appears to have been particularly weak, dependent on Mr. Chow alone, doesn't necessarily mean that there wasn't, that the jury didn't favour the prosecution in light of what had happened, unconsciously favoured the prosecution. Now, my learned friend, in terms of jury independence and the relevance of Mr. Williams' acquittal, initially cited Gregory. Gregory, in fact, was the one where it was the case where the European Court found no violation of Article 6 in light of directions. Gregory, though, was followed by Sander, which my learned friend, I think, this morning accepted was the case where one person had been acquitted. The approach of the majority of the European Court was to find, and you see this, I think it's 7956, paragraph 30, was to find a violation of Article 6 because a racist juror can't be expected to change their views in response to a direction. Now that is, we would submit, consistent with Putnam recognising that there comes a point essentially at which prejudicial views become so embedded that you can't change your mind. My learned friend pointed to the dissenting judgment in Sander, but that's a dissenting judgment. The majority approach in our submission is the correct one, as I say, reflecting Putnam, and that demonstrates the real problem in relation to the second aspect of my learned friend's case, which is the impact on the other jurors, which is the judge simply didn't have the information to know whether or not this was a poison that could realistically be discounted on the basis of a direction. My learned friend also said you can discount unconscious bias because of the strength of the evidence. The jurors will essentially have said that they didn't need to consider the corruption because the case was so strong. The fundamental problem we would submit with that, ignoring some practical problems I'll come to in a moment, is that what that is doing is inviting the court to speculate about the jury's thinking. It doesn't know how the jury approached the decision making. By definition, the jurors may not know what factors, or every factor that influenced them. We are potentially talking here about unconscious bias, and that is obviously something that the jury won't necessarily be aware of. And it's particularly difficult for the court to understand effectively the impact of bias when it simply didn't sit through this long trial. My learned friend summarised the evidence, but just pick up a couple of points out of that, and a sort of fundamental point that's at the heart of this. He started by referring to Mr. Chow's evidence, but Mr. Chow's evidence was clearly rejected in part by the jury because Mr. Williams was acquitted. He then relied on the electronic exhibits, but as he accepts fairly, there were arguments about the integrity of those exhibits. That's a credibility issue. He finally says, the heart of the defence case was that various exhibits had been fabricated. That is a credibility issue. That's an issue that requires assessment of what the officers and others said in cross-examination. And we would submit it's impossible for this court, many years after the event, with transcripts, but not much else essentially, to assess the extent to which the jury would inevitably have discounted, because of the strength of the evidence, prejudicial material. In any event, fundamentally, that explains why there is a right to trial by an independent jury, because it's for the jury to assess facts. What my learned friend's submissions do is potentially undermine that right. And that explains why all the authorities demonstrate essentially that the proviso doesn't apply. What my learned friend was seeking to do in my submission was seeking to apply the proviso, having accepted later in his submissions that the proviso can't apply to an unfair trial. Well, if it's a biased jury, you have an unfair trial. And that's entirely consistent with Serafin as well, because it clearly, if the jury was unlawful because it was biased or indeed didn't comply with the Jury Act, Serafin paragraph 49 in our submission makes it clear the verdict can't be upheld. In terms of directions, Bonnet-Taylor in our submission reflects the approach in Smith that directions must be apposite, clear and emphatic. The reference to Smith I gave in opening, it's 7671 paragraph 24. The direction in Bonnet-Taylor that was upheld at 629024 was a specific direction.
Sorry, 6290.
6290 paragraph 24.
Thank you.
And that's the context of what followed, which was the assumption that the jury would follow the direction. It's important to note, however, that paragraph 25, the statement that there is an assumption that the jury will follow a direction, was then followed by paragraph 26, which started with the word however, making it clear there was a degree of qualification, that emphasized the importance of the protocol, the need to investigate, because you can't, in one sense, rely on a direction until you're satisfied that the matter is capable of being cured. Here, the problem with the directions were, firstly, they were to a juror who'd already demonstrated they would not comply with the oath. Secondly, those directions were given in the context of what was, by our calculations, a 5-day summing up, where there had been repeated references to the need to comply with the oath. And that, in one sense, means this just looked like a repeat of those directions. And those directions had been given in the circumstances where it would have been clear to the jury that the judge was concerned that they might be influenced by the fame of at least one of the defendants. And so the focus of those directions was, be cautious, you'll read a lot about this trial, essentially, but you'll be, and so there was essentially another direction, didn't expressly reference fame, but it was in the context of a situation where the judge was clearly expressing concerns about the impact of fame. In any event, as I say, we would say you can't give a direction that in circumstances where there is a risk of unconscious bias. It's very difficult to direct the jury in a way that will overcome that, if it's sufficiently embedded, at least.
Why are we assuming it's unconscious bias? If every member of the jury has been approached and offered a bribe to acquit the defendants, I would think it was a quite conscious bias.
Well,
the jury would think, but the law does not think, that would be a relevant matter going to their guilt or innocence. But of course, their job is to decide it in accordance with the evidence. Isn't the real problem here that it would be a temptation hard to resist to decide or to be influenced in the decision of the case by something other than the evidence presented to the court?
Well, to be clear, I'm not saying it wasn't conscious bias. What I'm dealing with, what I'm dealing with is, in one sense, my learned friend's submission, which is to say, you can trust the jury to comply with a direction that they should, there is a problem with how detailed the direction was, but let's assume that the direction was sufficiently detailed. You can trust the jury to comply with a direction that they should disregard this factor. There's no reason in practice why it couldn't have said, because the jury were all meant to be aware of the bribe. I'm aware some of you have been approached about a bribe. You should. Now, the prosecution submission is you can trust the jury to comply with that. Whether that's realistic as a matter of human nature may be open to question. But assuming that's right, you still have the problem that even if a juror says to themselves, I understand that this looks pretty bad, that there was a bribe offered to us, but I understand what the judge has said. I need to put that out of my mind. It is very difficult, and this is why I focused on the unconscious bias aspect. It's very difficult as a matter of human nature to actually stop yourself unconsciously being influenced by that, because that's the way unconscious bias works. And that's why it's because I'm in one sense focusing on a particular difficulty that in our submission simply can't be addressed by a direction. But I accept that in reality, conscious bias is a very real problem here. Yes, can I am in terms of just a couple of final features. Firstly, the procedure adopted. All we would invite the court to look at is because my learned friend relies on it very heavily.